Good morning, Mr. Allerton.
Good morning. Elizabeth Doherty. I represent the defendant in this matter, Helder Barbosa. May it please the court. As I've raised a number of issues in my brief, I believe the first one that I will address this morning is the DNA testimony from the criminalist, Julie Lynch, the criminalist, who testified. Although she was not, as the record indicates, was not the analyst who tested these results. During her testimony, and the Commonwealth acknowledges this, during her testimony she recited verbatim all of the findings of the non-testifying, not available. Thank you. She recited all of the findings of the non-available or the non-testifying analyst at trial. And then also that test results table was also admitted into evidence.
Well, the Commonwealth conceded that the table was inadmissible.
Yes, and I believe they also concede that the recitation of the findings was also, that would be inadmissible under Nardi. I would argue.
Finish. I have a question.
I would also argue, though, that Ms. Lynch's opinion was also inadmissible because although she was able to offer an opinion, she was offering an opinion on clearly inadmissible evidence, evidence that had not been tested by cross-examination, so therefore would be clearly in violation of the Supreme Court statements in Melendez-Diaz.
Well, let me ask you this, though. Take it back to the medical examiner context. Don't our cases say on that point that even though the autopsy report isn't admissible and wasn't in evidence itself, that the substitute medical examiner can testify to his or her opinion about cause of death and a variety of other issues that may be based on the reading, his or her own reading of the autopsy report.
Well, that's certainly.
So what's different here, if you put aside for the minute that the actual table went into evidence?
Well, there's a couple of things that are different, and secondly, I'll sort of get to the contrasting an autopsy report versus DNA evidence. But I think if you look at Nardi, which all of these cases sort of come from, in that case, what they're basing the opinion of the medical examiner on is that it's a permissible basis for which someone can make their opinion. And they base that on basically Rule 703 of the Mass Rules of Evidence and Rule 705. I would point out that, in fact, this state has not adopted the federal rule of Evidence 703, which allows it to be based on inadmissible evidence. And I would say right there, you get sort of it's sort of pitting against each other the rules of evidence and the confrontation clause. And certainly, as Crawford has said, as Gonzalez, this court has said, when you're pitting the rules of evidence against the Constitution must trump it in every case. And so, in effect, basically what's happening is the opinion of Ms. Lynch was clearly based on inadmissible evidence. It's a way of allowing in untested, perhaps unreliable, because they've not been confronted by the one means to test this evidence. Confrontation.
I guess the thing that Justice Botsford is asking you, or at least I'm going to ask you, is why can the medical examiner testify to, based on his own opinion, to what was contained in an autopsy report, which is not admissible? So why couldn't this chemist testify as to her own opinion on the basis of a DNA test and series of results that are not admissible?
She's basing her opinion entirely on the findings of the non-testifying analyst. She did not run any of the tests herself. She, at trial, her testimony was based on...
Is it because in the autopsy case, the ME is testifying to things that he observed in the photographs, and is that why?
Well, that's part of it. In Nardi, they talk about the things that the medical examiner based his testimony on, the substitute medical examiner. He based it on testimony that he heard at trial, testimony that was presented there, photographs that were introduced at trial, which were admissible, and the autopsy report, and that was one thing that was inadmissible. I'd also suggest, and this was
the autopsy report was inadmissible.
was inadmissible.
Are you suggesting that to the extent that Nardi and Avila do not distinguish between evidence that was admitted, photographs, and evidence that was not admitted, autopsy report, and that the opinion is based on both, that Avila and Nardi are inconsistent with Crawford and Melendez-Diaz?
Well, I'm not sure that I'm exactly suggesting that, but what I am suggesting is that basing an opinion on clearly inadmissible evidence, in this case, the findings of an analyst that had not been tested by cross-examination, I would suggest flies in the face of Melendez-Diaz.
We don't have to reach the question that Chief Justice Marshall raised, because in this case, the analyst who testified, her testimony was based wholly on inadmissible
It was entirely.
facts. if you want to
Yes.
say, yeah.
Now, in In re Juvenile, which is I think the case from which Nardi derives, the standard was that one can offer an opinion based on evidence that would be admissible if the declarant of the underlying testimony would be testifying, not that it was admitted.
Well,
So you'd be asking us essentially to change In re Juvenile, aren't you?
well, yes, and I know there's, and that's troubling that there's a footnote.
Wait, I don't understand that, because that says evidence that would be admissible. Here, the table wouldn't be admissible unless that person testified.
Right.
It
But
would be admissible
it would
if
be
that
admissible.
person testified.
That's
And
what it
it's-
means.
I mean, I guess that's sort of the point, is that, yes, had the non-testifying analyst been there to testify, it would have been admissible, but she was not, and she was not cross-examined.
Isn't the real problem here that, as a practical matter, an opinion that the 16 alleles are the same, or whatever that was, is basically the exact thing of somebody saying, I tested it and they're the same. In other words, the opinion and the fact, there's no difference between the opinion and the fact, which may not be the case in, for example, the medical examiner situation. You may read an autopsy report and see that there was a knife wound to the heart and it punctured the aorta and whatever else, and you could say, it is my opinion, based on what I read, that he died of a knife wound to the heart. I mean, there's a break between the report and the opinion, and what you're saying, I think, is there isn't such a break here.
Right. Well, yes. I think that's
In
right.
effect, this is like a drug certificate, in other words.
Well, it is. I mean,
And are you saying, therefore, I guess that gets to the Chief Justice's question, but goes back even further, that maybe In re Juvenile is inconsistent with Crawford?
Well, that may be.
Because it's saying that you can base an opinion on something which would be admissible but isn't, so there's no opportunity to cross-examine.
That's a
I mean,
cardinal
certainly,
rule of evidence in both state and federal
I
courts.
know.
Excuse me?
That's a cardinal rule of expert evidence in state and federal courts.
Well, I will. As I pointed out before, this court has not adopted Rule 703. They have a different take
Adopted half of it.
on half of it, not
Isn't it 803?
703.
703?
Yeah.
Okay. Half of it.
what I think this sort of goes off on another point, but talking about what is there's somewhat of a difference in addition to the sort of what you were talking about, the autopsy report. The other difference, and this is a case that is cited in Nardi, which I provided to the court. I didn't cite it in either in my brief or in my reply brief, but United States versus De La Cruz. And in that case, they start to talk about some of the policy reasons why it would be very difficult not to allow an opinion as to an autopsy report. And of course, an autopsy report would be perhaps impossible, if not very difficult, to be replicated. Whereas with a DNA analyst, it could be replicated. And in fact,
But you say that, but I mean, in many cases, the DNA is exhausted during the course of the examination.
Well,
So
in particular, in this case, it apparently is not. Ben.
that would mean then, I mean, if you're right, then that means that whenever the person who did the DNA analysis is not available or has died, that the DNA would have to be done again for it to be admitted at trial.
Well, as I say, in this particular case, as an example, there has been the DNA, there is additional DNA for testing.
Okay, but I guess the question is, here there's no objection.
Yeah.
So
There was no objection.
So the logic of what you're arguing is that although there was no objection to this testimony coming in, that the prosecutor should still have gone to the time and expense of arranging for a new DNA sample to be sent to this new expert so that she could do it.
Well,
And how would she know that? Because, I mean, that would mean, I mean, in terms of the logistics of trial, that couldn't be done that fast. I mean, she can't do it on the spot.
well, a couple of things. With respect to the objection, which of course goes to the standard of review of the error in this case did precede Melendez-Diaz, and that case, of course,
It preceded the granting of cert.
It did.
But this is not a certification. This is not the DNA certification that came in. This is really a Crawford-type claim, not a Melendez-Diaz type claim.
Well, that is true, and it didn't.
Well, let me ask you this, and I really apologize if you don't know about the petition for cert. There is pending, as you may know, in the United States Supreme Court, a petition for cert on precisely this point. Precisely this point.
Are you talking about Krager?
No,
Is that Indiana?
Penderglass
Okay.
against the state of Indiana, which has been through, as I understand it, a couple of consultations of the justices. This is my question to you. Assuming, and in that case, the state of Indiana concluded, in the light of Melendez-Diaz, in circumstances very similar to this, that the opinion testimony of the non-DNA analyst was admissible. I'm going to ask the Commonwealth the same question. So this is hypothetical, but a decision will come down, I would say, at least within 130 days, which is our presumptive. So I'm asking you to try to give me some guidance, assuming that A, cert is granted. What, if anything, should we make of that? And B, cert is not granted. What, if anything, should we make of that?
Well, I guess I don't know that I know the answer to that question.
It is precisely
Yes.
this question, which is, as Justice Gantz, has suggested, that, this is not the DNA certificate coming in. That's not, and nevertheless there's a significant challenge. And, it's part of what's happening in the wake of Melendez-Diaz.
Well,
one way to do it is to say, I don't know, it doesn't have any impact, wait until the Supreme Court decides, because the granting of cert is neither here nor there. That would be a perfectly okay way to proceed.
I guess I just wouldn't really know the answer to
Okay.
that question. I do know that that obviously I would be naive not to think that a lot of the sort of ramifications of this and the practical considerations are not a consideration that this court is going to take into consideration, or other courts. But I will say that I will hearken back to Melendez-Diaz, in which they talk about that the right of cross-examination and the right of confrontation, rather, is not to be sacrificed to make things easier for the prosecution. And so it cannot be sacrificed for those reasons.
But the difference here in these types of cases is not simply the inconvenience of having to call an examiner to testify to a rather ministerial observation, that is, this is a firearm or this is cocaine. It is to lose cases where the DNA has been exhausted, or where the person who did the autopsy has passed away. This is not a matter of inconvenience. This is a matter of whether cases are going to reach conviction or not.
Well, I know in some of the cases that I've looked at, I mean, there have been a number of suggestions raised, such as perhaps having two analysts on each step of the way, perhaps videotaping the analyzation, because the question here is whether there was contamination or an error or worse, fraud. And perhaps a videotaping might be a somewhat less onerous measure. I will suggest that many of the cases also look at whether the testifying analysts whether they're able to give an opinion to the accuracy of the test. That was not the case in this case. I believe that there are 4 steps that the expert witness, Ms. Lynch, talked about in terms of DNA testing, and it would seem that in this case the step during which error or problems could result would be the extraction process, and the testifying analyst was not able to testify as to what took place at that point. And that would be the step for which cross-examination would be necessary to be able to test the reliability and accuracy of the evidence against the defendant in this case.
I'm going back to, it's troubling me, and I haven't reached a conclusion, but it's bothersome. The concept from Commonwealth versus a juvenile, or in re juvenile, whatever it is, that I know is established law, but so were things established in Crawford and Melendez-Diaz threw them out. If we say that an opinion can base her testimony, an expert can base her testimony, an expert can base her opinion on otherwise admissible evidence, even if that evidence isn't admissible. I mean,
it has not been admitted.
Has not been admitted. Isn't that, and is not going to be admitted in this trial, isn't that a Crawford violation?
I believe admitting evidence based on inadmissible evidence is precisely a Crawford. It's a backdoor way.
Ms. Doherty, it would be helpful to me if you didn't say admissible and inadmissible.
I'm sorry.
That has not been admitted. Okay. It's not that it's inadmissible. If the DNA analyst who performed the analysis were present and available for cross-examination, her results would be admissible. So let's clarify between basing an opinion on evidence that is not on facts that are not in evidence. They are not inadmissible, correct?
They're otherwise admissible, but they're not admitted.
But that's right, and your point is well taken, Your Honor.
Otherwise, we get into that you can't, that somehow it's not admissible in any circumstances, in which case it doesn't even meet juvenile.
But I was going to say, it's not to be overly simplistic, but yes, the non-testifying analyst, were she there, could have testified to all of this, and there would not have been a problem. But that, in fact, is the problem, that she was not there, and she could not be asked questions about the testing process. And that
I take it the way, at least I think we have to at least decide that if we find that this testimony is admissible, we have to say, in Melendez-Diaz, assuming that we had an expert on cocaine, The certificate doesn't come in, but the expert says, I have looked at this certificate. No, I didn't do the testing, but I see that, and I don't have a cocaine certificate in front of me to say, I tested it for this, and I tested it for that, and I tested. There was a test for A, there was a test for B, there was a test for C, and if you get the results A, B, and C that this certificate got, then, in my opinion, that is cocaine.
I think that would still violate Melendez-Diaz because.
But what's the difference between that and what the substitute medical examiner does in Nardi and Avila and Pena?
Well, she's saying some of that evidence is in the pictures.
True.
Some.
And the testimony that was admitted at trial for which they based their. This is entirely based, the opinion is entirely based on evidence that came in through the.
I know your time is up, and believe me, you can have as much time as you like, Ms. Kostolitz. This was not objected to, and so first we have to decide whether, it's a substantial likelihood of miscarriage of justice, or whether we apply harmless beyond a reasonable doubt because of the Melendez-Diaz issues, but let's assume it's substantial likelihood of a miscarriage of justice. Why is this, in this case, a substantial likelihood of a miscarriage? I mean, I read your brief. I mean, I've read both briefs. But sort of think of me as the jury, right?
This evidence that came in was, of course, scientific evidence, which juries are going to consider very probative. It was the one evidence that definitively tied the defendant to being at or near.
What about the crime? What about the gun? The DNA, I grant you, bolsters the identification evidence greatly in my mind. But what about the gun? The gun was separately tested, and the testing witness was there to testify, so there's no problem. And the police officer says, I saw this man, the defendant, drop this gun in this gutter, and then there's testimony that they got it out quickly and easily, so that meant it had just been dropped in the gutter.
Well,
and then there's testimony tying the gun to the death, the victim.
And the defendant admitted essentially admitted being at the scene of the crime.
Well, first of all, to Justice Cowan's, the police officer, I believe, did not see the defendant drop the gun into the
splash.
He heard a splash.
Okay, one can infer.
So there is some attenuation.
Perfectly reasonable inference. There's no piling on. Okay.
I'll grant you that, but it's somewhat more attenuated, whereas the scientific evidence is more definitive. And then the defendant, he did not admit to being at the shooting. I don't believe he admitted to being at the shooting.
Well, he had said to the police officers, there's a couple of guys back there that were, I forget exactly what he said. They're acting crazy. That's why I'm running.
He did not admit culpability to
No, that's not what I'm saying. But he admitted being right back there where the people had been shot, where the victim had been shot.
I would grant you that there is considerable circumstantial evidence in this case, but I would certainly argue that that pales next to the DNA evidence, again, in the minds of the jury, who would find that certainly very, very probative. And I've cited a number of law review articles sort of citing the CSI effect, that juries are going to in many cases they're going to consider the scientific evidence much more over the other evidence. And in fact, as I pointed out in my brief, the prosecutor in his closing argument relies on that, where he says, well, and we have one thing that can't lie or whatever, it's science. So I would argue that the DNA evidence was highly prejudicial and high.
Thank you, Ms. Dougherty. Good morning, Ms. Kostolitz.
Good morning, Chief Justice. Good morning, Your Honors. May it please the Court. Elizabeth Kostolitz, Assistant District Attorney on behalf of the Commonwealth. I would turn to the DNA issue first. And in Commonwealth...
Excuse me. Were you aware of the case that's pending on cert?
I actually didn't know that that had been granted cert.
No, it's not been granted.
Oh.
No,
then
it's pending.
Okay. I wasn't aware. I did read several extra-jurisdictional cases on this issue, and they have come out differently.
Correct.
Some have found that the evidence isn't testimonial at all. Some have found that it is. Some have found error. Some have found no error. I recognize the name Pendergrass. I don't remember the facts
It's fine.
exactly.
It's fine. But it's a. It is a case of the highest court of Indiana, which supports the Commonwealth's position. I'm not sure that the way you introduced the evidence of the opinion was exactly the way that it was introduced in Indiana, but it would certainly suggest that that with respect to DNA evidence, you do not need the DNA analyst there.
Right, and I would actually point the court to Commonwealth versus Avila, which is a post-Melendez-Diaz case, which again reaffirms that it is permissible to base an expert opinion on evidence that's otherwise admissible. And I think what saves it from a Crawford violation is that otherwise admissible testimony, or excuse me, those otherwise admissible facts, primary facts, are not allowed to be introduced on direct examination. The expert is merely allowed to say, my opinion.
But weren't they introduced here on direct examination?
Yes, and I can see that it was error. But
So
in the
what-
normal
what-
course,
let's assume what do you call it? The table. No table
Yes.
comes in.
yes,
And she's on direct,
Yes.
Ms. Lynch. What can you ask her? I know you can, and let me put to one side, because I know you can ask her about her opinion about, the likelihood, the statistical probability is one of whatever.
Yes.
But what can you ask her about the actual testing?
well,
I back up on that. I'm sorry. I'm not so sure you can ask her about the likelihood, because if you don't have the tables and evidence, what is the likelihood relevant to? I see no relevance of the likelihood numbers at all if you don't have those tables and evidence, so they become immaterial.
Well, no, I would disagree. First, the Commonwealth would be able to ask, about the training and experience of the analyst,
Wonderful.
about generally, how do you do DNA testing, about, we match known samples
Well,
to
I don't
unknown.
know. If there's no evidence of DNA testing, it might be inadmissible.
Let's just get over that for.
Well, no, general DNA testing, I think that that's admissible. I mean, there's no findings that are coming in. Generally, we match samples, unknown samples to known samples. And then in this case, did you do was DNA testing done? Yes. Did you review
Objection.
that
Oh,
testing?
did you? Okay, I'm sorry. Yeah.
And yes, and what was your conclusion? And that's allowed to come in.
When you say that's allowed to come in, that's precisely the issue.
Well, in Commonwealth versus
No,
Avila.
I understand.
Right. So if we keep within Avila, that the expert opinion is allowed to be based on facts that are otherwise admissible, which in this case they certainly are. If Delator had testified, she would have been able to testify as to her findings on the extraction and amplification.
Let me ask you about the tables themselves.
Yes.
I haven't seen them, but are they gobbledygook? I mean, would a juror be able to make any sense out of anything by looking at the tables?
I don't think so. They're included in the defendant's appendix.
Yeah.
And they're just numbers. So it's, 15, 15, and then 15, 15, and then 15, 11. So
Okay.
I think without expert testimony, they don't mean anything.
All right.
Which I think goes to the point why there is not a substantial likelihood of a miscarriage of justice in this case if the expert opinion is properly admitted, which the Commonwealth contends it is.
But the expert's opinion, I gather, though I've not read the testimony, was that if you get 16 out of 16, there's a certain probability.
Yes. And so, okay, going back to...
So implicit in that, the jury had to understand that here there were 16 out of 16.
You wouldn't be saying to the expert, what if they're 8 out of 16? What if they're 10 out of 16?
No.
What if they're 12 out of 16, 14, 16, 16? Thank you, Dr. Lynch.
Right, but I think...
So you
But it wouldn't be relevant to anything. You couldn't get that in. If you didn't have the tables, I don't think that, seems to me, that her testimony about what 16 out of 16 or 14 out of 16 means is inadmissible, because it's nothing but numbers out of thin air.
It's irrelevant.
Yeah, it's irrelevant.
Well, I would disagree because I think that the expert is allowed to testify based on information, even if not admitted, that would be otherwise admissible. In this case, that's the table. So she is allowed to look at that table independently, come up with an expert opinion, and then at trial testify to that opinion. And then that expert opinion also includes a statistical analysis. She's not allowed to explain how she got to that statistical analysis on direct examination, but she is allowed to do that analysis, come in at trial and testify, this is my opinion.
Do you
Now-
think, I'm sorry, do you think there's a difference between a medical autopsy report, I mean, an opinion as to death, the cause of death or how death occurred, when you have, as I think in both Avila and in Nardi, that you have some evidence that is some facts that are actually in evidence, typically the photographs, which would in any event come in. You don't need the photographer, I hope.
Right.
Right? I mean, I hope we don't need the photographer as well. But, and then, you know, I think in both of those cases, the doctor who was testifying had looked at the autopsy report, correct? Is there, do you see a difference between that and DNA?
I don't. I think
Okay.
that, again, it's just going back to basic expert opinion law. If it's otherwise admissible, even not, though it was not admitted, then the expert can draw their opinion, and that opinion is admissible. And I think what saves it from a Crawford violation, as I mentioned briefly earlier, is that it's not admissible on direct. The defendant can inquire on cross-examination about the foundational findings, the primary facts, and that's waiving his right to confrontation.
Okay, I just thought of a question. If we go on this otherwise admissible basis, what if in a drug certificate case, we had somebody there who's a chemist, drug chemist, and she wants to testify based on the drug certificate, and the drug certificate is otherwise admissible if you had the chemist there who had done the test, but you don't. Are you saying that the non-examining chemist can testify on the basis of that drug certificate?
Yes, but I would draw a little bit of a distinction. So with the drug certificates that we typically see in trials, they are just...
Yeah, I know what you're
Right,
saying.
so
Yeah,
they're
they
very
don't say
conclusory
anything.
and-
But if she had a report,
Yes,
this is like
certainly,
this test.
certainly. And I think-
For example, the Commonwealth has a problem on its hands. The person who did the testing is not available. She's out of state, she's disappeared, you know, she's deceased. And so they don't try to admit the certificate, but they get another expert, and who says, I've looked at, well, she can't be deceased because otherwise we couldn't get it in any, but let's just say she's out of state, but she could have testified to it. And she says, I've looked at the report. Based on your report, what is your opinion? My opinion is it was cocaine.
Well, if there's a multi-tiered level answer to that. I think that if the testing, the results of the testing, and not just the conclusion of the analyst who's not there, was available, not admitted because it's not admissible, but available, and then we have an expert to come in and testify who can look at that testing and determine, okay, that's cocaine based on, you know, the results of this testing, then certainly that expert can come in and testify.
So in the case of a person who was killed as a result of poisoning, an autopsy is performed, and there's no gunshot, no trauma to the body, and there is an autopsy report, and there's a toxicology report.
Right.
You get a pathologist who could come in and testify who had absolutely nothing to do with any of this and said that I based on my education, training, and experience, I've reviewed the autopsy report and I've reviewed the toxicology report, and in my opinion, this person died as a result of arsenic poisoning.
Well, right. I mean,
That's okay.
Yes, I think.
How is that not a denial of the right of confrontation, as the way the United States Supreme Court has told us?
Because you can cross-examine the testifying expert.
Exactly.
But you can't. But he doesn't know anything about the tests that were done. That
Well,
goes
no,
to
I
the-
would disagree. I think the testing would be included in the report, the toxicology report, and the defense counsel get up and ask about the report on cross-examination if he so wishes to, and he's thereby waiving, the defendant's waiving his confrontation right in that instance, which he is
Well,
allowed to
he
do.
doesn't necessarily have to waive it. He can ask questions about of the expert, saying you weren't present when the autopsy
Absolutely.
was performed, you weren't present when the blood was drawn or when it was tested.
Right, certainly, and can attack the credibility of the scientist, and can say how many times have you reviewed such reports and
No.
cross-examine
It's
that
not.
way.
It's not the credibility of the scientist and his or her opinion. Is it sufficient under Melendez-Diaz to be able to cross-examine the person who didn't conduct the testing when what you're trying to get at is that the testing may have been faulty. So if you say, is it sufficient to be able to say you didn't observe the test, you don't know the condition of the tester, whether he or she was tired, overworked, competent, or anything else, the prosecutor then gets up and says, Ms. Opinion Witness, have you reviewed, tests from, choose any laboratory, Cellmark or anything else? Yes. Have you actually worked at Cellmark? Yes. Have you visited the Cellmark facilities? Yes. Have you ever seen Cellmark make a mistake? No. But you still don't have the tester. Do you know this particular tester? And then you can go either way. Yes, no. Yes, I know her, and I know her to be a very careful or no, I didn't happen to know this tester. I mean, for Melendez-Diaz purposes, is that adequate?
Well, I would say yes, and I think in this case particularly, the defense counsel did a great job with that, because he raised a reasonable doubt by not having Cheryl Delator testify that he would never have been able to raise had she testified, which is he on direct, all of these findings came in about numbers, and then on cross-examination he said, well, let's explore how you get these numbers. There was somebody who extracted this DNA, it became colorless, they had to pour it into vial after vial, and then that wasn't you, though, was it? No. So you don't know whether that mislabeling, from vial to vial, there was a mislabeling. No, I don't know. Okay.
But can't you say the same thing about the drug certificate and the testing? A defense attorney could say to whoever testifies who didn't do the test, well, you didn't do the test, you didn't see it change color, you didn't do whatever it done, and I don't think the Supreme Court has said that we can do that.
Well, I think that certainly is a great way to raise reasonable doubt. If the defendant chooses, he can then say, well, you didn't do, or
can he then say to the judge, I've got somebody who's trying to opine on something in which he's got no basis to opine. Move to strike all the testimony. What's the trial judge going to do?
No,
I wasn't there. I didn't understand.
If the basis for the opinion was otherwise admissible testimony, no, he can't then say move to strike. He can attack on either of two grounds. He can either attack on, well, you didn't do the testing, so you don't know whether it's reliable, or he can start bringing in the subsidiary facts, which presumably he would have from discovery, whatever the expert was basing it on, even though it's not being admitted at trial. And there he can say, well, let's talk about these subsidiary facts, and then he's waiving his right to confrontation and bringing in the facts. So he has two options. Neither are violative of Crawford. One doesn't even implicate Crawford. The other does, but it's on cross-examination. It's the defendant's
Can I ask you a question on another subject? Why did the Commonwealth elicit denial testimony in this case?
Honestly, I don't know in the head of the prosecutor. I'm assuming he just assumed it was a party opponent statement. It was part of a larger statement. It wasn't entirely a denial. In preparation for argument, I read Diaz carefully and also looked at a few.
This isn't Diaz.
Well,
I don't think it's Diaz, anyway.
Okay, I think,
Yeah.
well, in my reading of Diaz, it was, I wasn't there, I wasn't in the car, I didn't, I wasn't involved in the crime. So it was a sort of unequivocal denial. In this case, it was, I was present, but I didn't shoot anyone, I didn't throw anything in the sewer. I think the thought process was just, well, it's a party opponent statement and admissible. I'm not sure whether the rule about post-Miranda denials means that if there's a denial within a larger statement that the defendant gives, where he's validly waived Miranda, gives a statement, and a portion of that statement is a denial, then you have to excise that denial.
But in Diaz, which you keep citing as to help you, in Diaz we said that there was error in admitting the denial, and all we did was decide whether the error required reversal.
Right, and I do say in my brief that it was error to admit it. I don't think it, I think it was just that the Commonwealth presumed it was a party opponent statement. I do step back a little bit from my concession in the brief because I'm not sure whether the rule is as broad as I initially thought, in that if there's an unequivocal denial, it has to be excised from a larger statement given after validly waived Miranda. I think some of the cases say it's only inadmissible when the entire statement was a denial.
Yeah. In this case, was the denials actually somewhat consistent with the defense at trial?
It was, certainly, it was.
And so the defendant was being consistent throughout?
I think, yeah, and I raised that in my brief as well. Perhaps it was a strategic on part of defense counsel because the defendant was caught at the scene. He was caught at the scene within a block of where the victims were found shot, within a minute of the officers receiving the radio call with the gun, after the splash that matched the ballistics. So there was a lot of evidence against him, and I think it was strategic to say, well, he was there, but he didn't do it.
Could I ask you, it's a factual question, I just can't figure it out, and maybe not terribly important, but these phone calls, the Nextel phone and the cell phone, and the phone, well, let me start here. The mother of the victim,
Yes.
I think it's the mother of the victim.
Yes.
Had a piece of paper with a number on it. Did
Yes.
that come into evidence?
She testified to it.
And what was
I
that? Was
believe.
that number connected to any phone that I should be caring about?
Miss Sarah testified her son had given her a yellow piece of paper with a name and phone number on it a week before he was killed. It was admitted over the defendant's objection.
What was admitted? The piece of paper?
The piece of paper. But she never said what the phone number was at that point. That's at Trial 2, Volume 2, 166.
Okay, and so what was the number belonging to something connected to who?
Well,
Yes.
the number, the piece of paper also had on it the letter C.
Yes.
And there was separate
Yeah,
testimony
no, I
that
know
C
that.
was the
I'm
defendant.
just trying to figure out the phone.
Right, sorry, I apologize. That piece of paper, I'm not sure what was on it. There was some piece of paper that was admitted through the mother. But later, there was testimony that after Sarah was murdered, the police recovered his wallet, and that contained a piece of paper with the phone number of the prepaid mobile phone and the letter C on it.
But then there's something in your brief, I think, about how the phone, the Nextel phone records
Right.
don't connect to anybody, so
Oh, no. So that phone number, right, that had the letter C on it, that was from the the victim's wallet. They
Okay.
then ran those records, and that number had 37 calls between September 23rd and 27th to and from Sarah's home.
okay. And that number is registered to the defendant?
It's not, it's a prepaid phone, so it's not registered to anyone, but it's on the
That he
piece of
had?
paper with C on it. So, does that
So
make
you'd
sense?
have to infer that the number and C are connected because they're on the same piece of paper?
Yes, but that's
And
only,
there's a separate testimony that C is
Yeah,
the
right, I know
nickname by which
Yes.
the defendant was known.
yes.
But I have a question. How do you get into evidence the mother's statement that Surratt, the ultimate victim here, told her that he and Kabuchia had seen something on September 21st? How is that admissible?
As state of mind evidence, and it does
Whose
seem a
state
bit-
of mind?
The victim's, Sarah's.
And it was known to, and it was known to the defendant by virtue of the telephone call. That's your
Well, and
argument.
also that the defendant saw the victim and spoke to Sarah on the day of the earlier murder on September 21st.
How do you tie the telephone call into the defendant? I mean,
So the Commonwealth's theory was that, so the phone number, the prepaid phone,
that he had
was
written down on a piece of paper?
with the letter C, that Sarah had with the letter C, which is the defendant's nickname.
Yeah.
After running a record for those phone numbers, there were 37 calls to and from that number to Sarah.
And one of them was or at least one of them was a phone call right around the time when he became visibly upset in front of his mother?
37 calls
All right.
between the 23rd and the 27th. The earlier shooting was on the 21st.
Okay.
But I think even stronger than that is the fact that on the 24th, right before the defendant went to shoot the earlier victim, Sarah said to him, Sarah was there, Sarah and Carbuccia, Sarah said, "What's up?" to the defendant. The defendant said, "I can't talk now," immediately went over to the other car, pulled the victim of that earlier shooting out, shot him in the head.
Well, there's evidence that the defendant knew Surratt and Kabuchia had
Were there,
witnessed it.
right. And
Right.
so that, since the state of mind of the victim is, I saw something, that's been communicated to the defendant. He knows that the victim was there. So I think it's the state of mind, and it's admissible on
So
that
it
issue.
could also be cumulative.
Absolutely. I think it's certainly cumulative, especially because the statement's not he saw something, it's they saw something. And Carbuccia testified about that earlier motive, that September 21st shooting, that both of them were there, that they both saw it. So I think not only is it cumulative, but admissible under that.
Now, if I could ask you about
Yes.
the DG and Batista issue.
Yes.
Was there any humane practice instruction given in this case or requested in this case?
I think there was. I can
I didn't see it in the
double-check.
closing. It was not part of the closing instructions, I don't think, was it?
I thought there was. I thought that it was requested and given, but I'm not positive. I can write a letter to the court.
Well, it's either there or not, so.
Right, right. And if there's no other questions, then the Commonwealth asks the court to affirm the conviction.
Thank you, Ms.
Thank you.
Costello.